is Christian Phillip.
Natalie Zund on behalf of the people.
Good afternoon, Your Honor. Rita White on behalf of, please state your name for the record, Mr. Phillip.
Christian Jeremiah Philip.
This is your motion. You may go ahead.
Yes, Your Honor. I did submit and file a motion with to the court, and I did provide notice to the prosecutor's office back in late August. Your Honor, I filed a motion requesting withdrawal of Mr. Phillip's plea. I did initially speak with an attorney on the morning of the plea, and I was advised that the nature of the charges that Mr. Phillip was offered in terms of pleading guilty to one count of domestic violence under 769.4A, and then a reduction to attempt R&O of a police officer resisting obstructing, which reduced it down to a misdemeanor with a dismissal of the remaining charges with potential diversion on the R&O, and again, under advisement on the domestic violence charge would be okay. However, would not provide any consequences to his immigration status because Mr. Phillip is currently a green card holder. He does have permanent residence, but he is not a full citizen of the United States. So after speaking and go further, my own independent immigration attorney profession self, I did some further research into potential possible issues that may arise given the fact that this domestic violence charge does carry a level of moral turpitude. So I did consult with an experienced immigration attorney that now I see was much more experienced than the previous attorney that I spoke with, and realized that I provided misinformation to Mr. Phillip in terms of his immigration consequences. And given the fact that this attorney that I spoke to provided a very detailed 6-page letter with case law statutes that really connect to Mr. Phillip's potential consequences, which will lead to a high level of deportation if he does plead and accept the offer that he was provided. I did advise Mr. Phillip of his consequences, as he did also was advised by the immigration attorney that he met with for at least over several hours. They went through in detail all of the factors regarding this case and his background, etc. So based on the fact that either way, I do not want my client put in a position where he would be deported, given the fact that his wife is with him, who is the complainant. They have young children. They've lived in the United States for many years. They both are working, and I don't want to break up the family or cause any distress. So I would really like to proceed with renegotiating this matter further. So with that, based on my client not knowingly, voluntarily entering into the plea, given his misinformation of his immigration consequences, I'm asking that you grant my request to withdraw his plea.
How does that relate to knowing? I mean, he knew what he was pleading to.
Correct.
I mean, nothing in what the plea was affected the voluntariness of the plea.
Yes, Your
Right?
Honor, it did affect the voluntariness of the plea because had he been advised of the actual nature and potential consequences of his immigration status, he would not have entered into the plea, nor would I have advised him to enter into the plea.
Response from the people.
Your Honor, the people believe at the time the plea was entered that it was knowing and voluntary, as the defendant did have a chance to talk to an immigration attorney. However, we would leave this in the discretion of the court.
When I read the motion, I don't want anybody necessarily breaking privilege, but I have the representations of counsel regarding this, but I don't have any of the documentation that you're claiming causes the plea to be set aside. And what gives the court some hesitation in that regard is this was never this case wasn't about his immigration status as we were going through everything prior to the plea and anything being taken. This was about potentially mental health concerns, other things that might have been going on, but it was not certainly about that issue. It then gets before Judge Freshour for the entry of for sentencing, and then it becomes about this issue. So while the issue on the face of it might be one that the court should be concerned about, I have nothing to say that you talk about a 6-page letter. I don't have that letter. I don't have anything on the one hand that says he received certain advice the first time with the plea, and then received advice in a different direction afterwards. So where is that information?
Your Honor, just to give you a little bit of timeline, after my client took the plea prior to the sentencing, I did submit a lengthy deviation letter to the prosecutor's office, given the fact that it flagged my current concern with his immigration consequences. So what happened then is I received a response from the prosecutor's office indicating they too would like to meet to look into a second opinion from an immigration attorney to provide further background in terms of Mr. Phillips' possible immigration consequences. I did indeed do that, and I did provide a copy to APA Kirby, also the prosecutor that oversees the entire office, and some other accompanying assistant prosecutors. And that's when I did receive a response that either we proceed with withdrawal of the plea or we proceed with this sentencing. However, this is a privileged letter that I would prefer that if it's going to be sent with you, sent to you, it stays with you. But I would have no issue in terms of recalling this case, putting it over for you to review this letter that would provide this court very learned information regarding immigration consequences when it comes to criminal matters. So I can provide.
But no, it's not. That's not the issue, Ms. White. The issue is the claim here is that at the time of the plea, he was advised of one thing. Then subsequently, he's advised of something else. I have neither before me with this motion to withdraw the plea.
Yes,
and
Your Honor.
it wasn't something, at least from the court's perspective and the court's recollection of the case, that was even at issue in the prior proceedings.
Yes, Your Honor. With regards to advice to a client, as we know, attorney-client privilege stands, and I am not going to place a record of a transcript of my conversation with Mr. Phillip, advising him of what his immigration consequences were or are. What this is this was an off-the-record conversation that I had with Mr. Phillip with an immigration attorney on the date of sentencing. And that's when, Your Honor, as you went through his constitutional rights, I do recall, we can pull the transcript, but I'm certain and confident that you did speak with Mr. Phillip on the record and asked him, is he aware of his immigration consequences regarding taking this plea? Mr. Phillip answered in the positive. Yes, he was. But however, this is not about Mr. Phillips. If this case is pursuant to Padilla v. Kentucky, is about ineffective assistance. This is my issue. I misadvised Mr. Phillip of his immigration consequences from receiving misinformation from a different attorney.
Well, that then gets to a whole other issue of potentially having, and I was trying to avoid it, but if that's how you view the issue, then I've got to have a hearing.
That's fine.
I mean, I have to have an evidentiary hearing. I mean, I'm trying to avoid it because you're telling me there's one thing that happened, there's this. You want to cloak that in attorney-client privilege. I get that, but I can't. I mean, otherwise, what ends up happening is every plea I take would be subject to being set aside on some grounds that the court can't even see. You're telling me there's a 6-page letter. Okay, that's out there. You're telling me that there's other advice previous. Again, I don't have either one of them. And then when I tell you I don't have either one, you say, well, it's not on the defendant, who I guess would have used that advice. That is all of a sudden on you, and that ineffective assistance of counsel which if that's the case, then I've got a whole other issue for me to deal with. So you want me to set this for an evidentiary hearing against her? I mean, I'm not sure what you want me to do to try to get to the point where I could even begin to grant your relief.
Well, in terms of a Ginther hearing, the purpose of a Ginther hearing is to determine and find that an attorney was ineffective. I've been in practice for 23 years plus years, and I don't do this normally, but I will acknowledge that I was ineffective. And pursuant to Padilla v. Kentucky 559 U.S. 3656.
I know Padilla very well, counsel.
So I'm acknowledging I was ineffective, and he was misadvised of his immigration consequences.
But
and that would
counsel,
call for.
Can't do it that way. Because the problem would be that every plea that we take that somebody may not like, either the sentence or anything else, somebody would come forth and say, I'm ineffective, I didn't tell my client this, or I told them something, and I don't have a hearing to say whether or not that would have any impact.
I have no issue or problem with holding a Ginther hearing. I'm fine with that, in which Mr. Phillip would be prepared to testify also.
Well, okay. I don't have a problem setting that. But you understand that it can't be just your admission that you were ineffective.
Correct.
I mean, because somebody's going to have to back up that certain advice was given, potentially relied upon, shouldn't have been, and then there is this other evidence that was relied upon. I mean, it's going to come down to the same thing. But it doesn't matter to me how we do it, per se, but that's what's going to have to end up happening. How long will it take you to prepare for a Ginther?
Couple weeks, 2 weeks.
Do we have? It's going to have to be in person because I got. I'll set the Ginther hearing for Tuesday, October 3rd. That's in person. Before me, 9 a.m.
Your Honor, is 10 o'clock? Okay.
Pardon?
Will 10 o'clock work? I have a matter in Detroit at 9 a.m.
Fine, we'll set it at 10.
Thank you, Your Honor.
In today's docket, beginning with People v. Octavia Lewis, defense counsel noted the client prefers a different name but confirmed her appearance, and the court, after a brief tense exchange, adjourned the matter to October 5th for discovery. In People v. Halil Taylor Jefferson, counsel reported that the defendant's phone was disconnected and he again failed to appear. The judge issued bench warrants in both cases with a $25,000 cash surety bond, effective immediately. Next, in People v. Sean Jenkins, the defense requested an adjournment for continued discussions. But Mr. Jenkins personally addressed the court, claiming a conflict because his wife's cousin, whom he alleged previously threatened him, works for the public defender's office. The judge found no legal conflict, denied substitution of counsel, and set the next date for October 5th in People v. Robert Welch. The defense requested a 1-week adjournment to review a new misdemeanor-level plea offer and also sought a personal bond, arguing the defendant had completed inpatient treatment and was engaged in outpatient care. The prosecutor objected, citing the defendant's long absence from the system. The judge firmly denied bond reduction, warning the defendant that speaking further would not improve the ruling. In People v. Muhammad Al-Akhtar, the defense asked for a preliminary examination and informed the court of Al-Akhtar's significant medical issues and upcoming surgery. Timelines were waived, and the hearing was set for October 10th. with the judge instructing counsel to work with the prosecutor regarding modifications to tether restrictions if medically necessary. Finally, in People v. Scott Loendorf, the defense sought one last adjournment to monitor improvement on drug testing and treatment compliance. The prosecution alerted the court that Loendorf had left the state for a golf caddying job, an explicit bond violation, though the defense explained it was an oversight. The judge allowed bond to continue but issued a serious warning, emphasizing that any further violation would result in immediate consequences and instructing the defendant to review all bond conditions carefully before the next date on October 5th. For more information, like and subscribe to my channel.
People versus Octavia Lewis.
Nicole Hughes on behalf of the people.
Sandra White on behalf of Ms. Lewis. Your Honor, Ms. Lewis is present. She does not wish to respond under this name, but she is present. I don't know if Your Honor can see her.
So what name today does Miss Lewis wish to respond under? Miss Lewis and I kind of know each other.
I resent that statement made by the court. It is my natural name. I was adopted and then I incorporated my name. I am sorry, Mr. Johnson. I do not disrespect you, and I appreciate it if you did not disrespect my name.
Okay, so here's what we'll do. All right. Before this gets too far afield, I know that this is the individual that I know to be Octavia Lewis, as we call her here. So what do you want to do in this case, Miss White?
Yes, I was appointed to this case. I had the opportunity to speak to Ms. Lewis this morning. We are asking for an adjournment so that we can get discovery.
Without objection, probable cause conference will be adjourned. Let's just do October 5th. October 5th, 2023.
I'm through.
9 a.m. Bond continued. Thank you.
Thank you.
You're disrespectful.
Court calls the case of the people versus Khalil Taylor Jefferson. 2 cases.
Nicole Hughes on behalf of the people.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Taylor Jefferson. Mr. Taylor Jefferson, if you're present, would you please state your name?
Yeah, I'm not surprised. He's missed every. Go ahead. What?
I was just going to say that I do believe that he was at the last court date. I tried to reach him before today's hearing, and his phone was not in service. I'm assuming just needs the bill paid. We would ask for an adjournment.
Oh, you think it's because of the bill?
That
It
is
has nothing to
supposed
do with
work.
the QC.
You think it's the bill? You just throwing that out there.
Because
No, it's okay. It's okay. It's all you had. And
That's
man,
all
I
I-
get it.
Thank you. I appreciate that.
Because it might be why he missed his test too.
Oh, well,
No,
He's
that's
been
okay.
trying-
No, you don't have
he's
to
been
answer
working on that for a
I'm
long
just saying.
time.
I'm
He's
just
been working
saying.
on that for a while.
Bench warrant will issue for defendant's failure to appear in both cases. Bond is set in the amount of $25,000 cash surety. Those warrants will issue immediately.
Thank you.
Thank you, Your Honor.
Versus Sean Jenkins.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jenkins. Mr. Jenkins, can you unmute your device and state your name for the record? And please remove your hat, Mr. Jenkins, while you're in court.
Okay, just a minute. I gotta go over here.
Your Honor, we are asking for an adjournment of today's probable cause conference in order to have some additional conversations with Mr. Jenkins, as well as the prosecution in this case. My understanding is that Mr. Jenkins does have a request that he would like to address with the court himself.
Really?
That's correct. Mr. Jenkins?
Probable cause conference will be adjourned October 5th, 2023. 9 a.m. What do you want to address?
Yes, how you doing today, this morning, Your Honor?
I can't hear you.
Okay. I said how you was doing. I want to address the public defender representing me. I feel like there's a conflict. Well, I know there's a conflict of interest in the public defender representing me because my wife, her cousin, works for the public defender law firm, and she just threatened me like 2 weeks ago. So I don't feel comfortable with the public defender representing me. I don't want to get into detail about everything that happened and her and what she did, but I don't think that it would be in my best interest to be with someone that she works.
So who is it you say is who do you have the problem with at the public defender's office?
I believe her name is Roberta Higgins.
Okay, and what is she to you?
She's my wife's cousin.
Oh, she's your wife's cousin.
Yes.
Okay, and so what does that have to do with your case?
Well, see, what would have to do with my case is because like 3 weeks ago, she called and threatened me, talking about sending some guys over.
She was gonna send some guys over.
For me, that she would be trying to cause issues or problems with me. So, I know she's been working there for quite some time, and I know she know a lot of people that's in there, and I just don't feel that
she knows a lot of people that she gonna send over to your house?
would be representing me the best of my ability on account of
okay, so
her,
hold on a minute.
not liking
Just
me.
Hold on. Miss Apple, do you know anything about this?
Your Honor, Mr. Jenkins did make it clear that he would be requesting for our office to withdraw. I contacted management regarding his request, and at this time have been informed that there is not a conflict that would affect his representation by our office, but that Mr. Jenkins was free
And
to
so,
make his
Miss
request.
Apple, as of today, have you been contacted by anybody in the public defender's office to subvert, not zealously represent, or
No,
fulfill
Your
your
Honor.
duties as an attorney regarding his representation?
No, Your Honor, not in any way.
I didn't think so. Motion for withdrawal or motion to force the public defender to withdraw is denied. We'll see you October 5th. Bond continued.
Thank you.
Court does call the case of People versus Robert Welch.
Yes, sir, Your Honor.
Alex Chabalowski for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Welch. Mr. Welch, would you please state your name for the record?
Robert Jason Welch.
Your Honor, this morning I received an offer from Mr. Chabalowski that I think Mr. Welch would be interested in, but I do need an opportunity to discuss it with him. We are asking for a 1-week adjournment, and we'd also like to address the issue of bond.
Well, you guys are going to have, if this is not a brief bond motion, you guys are going to have to file these in writing, but go ahead and address bond. Probable cause, September 21st, 2023, 9 a.m. Go ahead with bond.
Your Honor, Mr. Floyd, pardon me, I was looking down and wrote next to the wrong name. Mr. Welch did miss court previously. However, since that time, he has participated in inpatient and is currently enrolled in outpatient substance abuse treatment. I did receive verification from his aunt of that completion of the inpatient treatment, and I forwarded that to Mr. Chabalowski just a few moments ago. It indicates that he was at Meridian, and in addition, and let me back up, he states he was there for 30 days, and it shows a completion date of, I want to say, August 25th. In addition, I have provided Mr. Chabalowski with verification that Mr. Floyd is participating with MRS. He is
Mr.
also.
Welch.
Pardon?
I'm Welch.
I do not know why I keep doing that. I am so
That's
sorry,
all right.
Mr. Welch.
That's okay.
That Mr. I'm saying the right facts, but the wrong name. I am so sorry.
Okay, that's okay.
Okay. that he is participating with MRS and that he is also in outpatient treatment. We are asking, and he is residing with his aunt and has family support. We are asking that he be granted a personal recognizance bond. The offer is a misdemeanor use, and I do think he'll be interested in that.
Response to the people.
Judge, my notes showed that he was gone since January before being picked up. I'll leave it to the court.
Motion for bond reduction denied. Bond will continue.
Sir, I've been like 50 days sober. I'd be very grateful and blessed for a personal bond.
So you think if you keep talking, it's going to change? Motion for bond reduction is denied.
Oh, I didn't that hearing. I had a hard time. I didn't even hear that, sir.
Yeah, okay. Well, denied. They said it louder. Thank you. Crazy People versus Mohammed Al Akhtar.
Marie Rosinski on behalf of the people.
Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Mohammed Al Akhtar. Mohammed, can you unmute?
Yes.
They're so cute when they're little.
Yeah, Mohammed Al Ashkar.
Al-Ashkar, sorry about that. Your Honor, we would like to set this matter for preliminary examination, and I'd like the court to be aware that Mohammed has been in and out of hospital, different hospitals. He's got surgery coming up within this week. The timeline for recovery is to be determined. He's also might have to have additional surgery, so I just want the court to be aware of that for the preliminary examination date. And I would also like to put.
You want me to set it out further, waiving your timelines, or you want me to set it for a normal schedule? Pray for the best. Tell me what you want, and I'll tell you what I'm gonna do.
I would do normal, but if I'm leaving that up to your discretion, Your Honor. I mean, if you know what, let's waive timelines and set it out, Your Honor.
You sure?
Yes, I'm sure. I'm sure.
That was his first case. It's gonna get better.
Oh,
All
Your
right.
Honor, I've been in front of Judge Kunke too.
Have you?
Yes, I've interned in front of Judge Kunke, so you got some big shoes to fill.
Did you do this before?
Yes.
No, I'm kidding. I'm messing with you. Preliminary examination will be set in person. Well, no, he wants it. He just waived the timeline finally. So we'll just set it October 10th, 2023, 9 a.m. before Judge Burke. Finally, we got
Your
a
Honor,
date.
if I may,
Yeah.
Just for my client's clarification and on my end, can we put on the record the tether conditions for my client? Because I see a hot zone on my end, but he just wants to know.
You see what?
I see a hot zone on my end, but he just wants to know if he can go to work and go get his surgery and take care of his own matters. If we can state that on the record, please.
Man, I have home confinement.
Okay. Is it possible that he can go take care of his matters outside of his home?
I guess, yeah, sure. But have you talked to the prosecutor about this?
I have not, Your Honor. I just wanted to clarify it first.
So somehow I figured that. So if he's got surgery and other things, maybe what you want to do is talk to the prosecutor, see if you guys can stipulate to something, send me an order. If not, I'll set it for a motion if you have to have a motion before his next day, even though I've already set the exam, or you can go to Judge Burke directly.
Thank you, Your Honor.
All right. Anything else?
Nothing
Or
further.
are we finally done with this one?
We're done. I'll see you soon.
Oh, okay, good. All right. Bond continued. Thank you. Is it Lohendorf?
Nimish Ganatra, First Assistant Prosecuting Attorney for the People. Edward Drukas for Scott Lohendorf.
Mr. Lohendorf, can you state your name, please?
Scott Lohendorf.
Thank you. All right, what are we doing?
Your Honor, I'm asking for one last brief adjournment. I'd ask for 3 weeks. I am in receipt of a progress report from Community Corrections in order to facilitate plea negotiations. I want to see a little bit better of a progress than he's been providing the court.
Without objection, probable cause October 5th, 2023, 9 a.m. or assumed by indicate the bond continue.
Your Honor, and I'd want
Yes.
the court to remind the defendant about the community corrections obligations. And among other things, it's my understanding that he left the state to go to Ohio. And maybe he's just dumb. He wasn't paying attention to the magistrate when the bond conditions were read, but he's getting pretty sloppy with this. And I want him to be aware of the consequences of him violating any of the conditions of the bond.
What do you mean he went to Ohio?
Your Honor, I can explain. In discussions with the prosecutor, there was a missed test. In explanation of that, he did go to a golf tournament. He was a caddy for a U.S. amateur who competed in a tournament, the USGA 4-ball tournament that was tucked into the corner of Ohio. And when I was just going over this with him, that came out from him, and I reiterated, did you understand that you can't leave the state? So I think it was something that he overlooked, and I think I've been very clear with him as far as what those conditions are. And I don't believe there will be another mistake by him.
Sir, you understand that?
Yes, Your Honor. I did not at the time know that I wasn't allowed to leave the state, and I didn't want to bail on my buddy that day. I've caddied for him all over the world, and it's a huge tournament, and he qualified for nationals that day, but I totally realize now that I wasn't supposed to do that.
Congratulations, but he may not be able to go with you any other place if I were to revoke your bond.
Yes, I understand that.
All right, anything, and now you're on a real short leash, because I want to see progress with this progress report. I know your counsel does in terms of this testing, but if I have one more mishap, we're going to have a problem.
I understand.
Or you're going to have a problem. I'm not going to have a problem.
Yes, Your Honor.
So you might want to take that sheet that you were given, your pretrial release order, go over that and make sure you understand everything that's on it. And if there's something on it you don't understand, you need to get to Mr. Drukas so he can explain it to you.
Yes, sir.
All right, I'll let bond continue at this point. Thank you.
Okay, thank you, Your Honor.
The next date again.
October 5th.
In today's docket, beginning with People v. Octavia Lewis, defense counsel noted the client prefers a different name but confirmed her appearance, and the court, after a brief tense exchange, adjourned the matter to October 5th for discovery. In People v. Halil Taylor Jefferson, counsel reported that the defendant's phone was disconnected and he again failed to appear. The judge issued bench warrants in both cases with a $25,000 cash surety bond, effective immediately. Next, in People v. Sean Jenkins, the defense requested an adjournment for continued discussions. But Mr. Jenkins personally addressed the court, claiming a conflict because his wife's cousin, whom he alleged previously threatened him, works for the public defender's office. The judge found no legal conflict, denied substitution of counsel, and set the next date for October 5th in People v. Robert Welch. The defense requested a 1-week adjournment to review a new misdemeanor-level plea offer and also sought a personal bond, arguing the defendant had completed inpatient treatment and was engaged in outpatient care. The prosecutor objected, citing the defendant's long absence from the system. The judge firmly denied bond reduction, warning the defendant that speaking further would not improve the ruling. In People v. Muhammad Al-Akhtar, the defense asked for a preliminary examination and informed the court of Al-Akhtar's significant medical issues and upcoming surgery. Timelines were waived and the hearing was set for October 10th, with the judge instructing counsel to work with the prosecutor regarding modifications to tether restrictions if medically necessary. Finally, in People v. Scott Loendorf, the defense sought one last adjournment to monitor improvement on drug testing and treatment compliance. The prosecution alerted the court that Loendorf had left the state for a golf caddying job, an explicit bond violation, though the defense explained it was an oversight. The judge allowed bond to continue but issued a serious warning, emphasizing that any further violation would result in immediate consequences and instructing the defendant to review all bond conditions carefully before the next date on October 5th. For more information, like and subscribe to my channel.